Beating off her rivals there at the Under-20 World Championships, Briana Williams. But the question is, can she beat off the charges that have been brought against her, as she is the subject of an anti-doping hearing which has concluded. Now the deliberations are going on, and she's wondering if she'll have time to get to Doha in good order to assist the Jamaica team and to advance her own personal agenda. We're speaking with Matthew Gayle. He is an attorney at law, a counsel from Trinidad and Tobago. He is a man who supported the Williams team in this matter, and he has made it clear that he is not a practicing attorney in Jamaica, but of course he's a learned member of the bar in the Commonwealth, in the Caribbean, and that's what justifies him being a part of the team and being in this space. I want to ask you, you said that it was irregular, and I've heard that term so many times over the past few months because I'm a junkie for the Brexit machinations in the Parliament, and I hear that a lot from the various speakers and who stand in the Commons to talk about it. For the chairman of the panel, Kent Gammon, to have issued the statement he did to the media, but you would accept, though, counsel, that there is a significant public interest element to the proceedings, to the fate of a darling of Jamaican track and field. You know how Jamaicans are with their track and field. In fact, you know how the entire Caribbean is with their track and field. And given that this matter concerns a minor, a darling of the Jamaican track and field loving public, it is good form, I'm suggesting to you, for the chairman to at least say something to the media in the way that Ken Gammon did. Now, I'm not commenting on the material of what he said, the text of what he said, but I'm just saying in the spirit of the interest in the case, it is good form, and certainly from my perspective, not that irregular for him to have spoken at the close of the proceedings yesterday.
I mean, I hear what you're saying, and in general and broad terms, I would agree. But I suppose why I said, I suppose I used the word irregular, and I guess I chose that word fairly carefully. There are two issues. The first is, and as I said, the procedural irregularities began at the case management phase of this, right?
Okay.
The panel, in particular, it seems driven by the chair, Mr. Gammon, chose to have the proceedings in camera, essentially closed away from the media, held away from the public eye. And you no doubt would have seen the leader of Briana Williams' legal team, the representative, Dr. Crown. You would have seen that Dr. Crown has been a proponent of open hearings.
Yes. Yeah,
and that was that was our position. Really, yes, there's certain elements, and perhaps Ms. Williams' evidence herself, because she is a minor, should be held in camera. But the proceedings on a whole are a matter of public interest, both nationally and internationally, quite frankly. So in the first instance, it's irregular because he has said himself that it should be held in camera. So that's an irregularity introduced by the chair and an inconsistency.
I'm going to interject after you make the second point, but go ahead.
The second point, which is the last one on this, is the contents of the comments. Now, I would have seen on Tuesday morning in the Gleaner, Mr. Gammon was quoted as saying words to the effect of the proceedings are going swimmingly.
Yeah.
Well, frankly, they were a procedural farce.
And they finished so quickly, as opposed to 2 days. Do you think you all got enough in?
I think the time, to be fair, I mean, these type of hearings they're time critical.
Okay.
And we would have been prepared, and our position always was that we were prepared to work through the night if we had to. And that would have been our ideal. But we understand the context, and we're coming from out of jurisdiction. A couple of days set aside. If we finish a little early, that's a bonus. So the timing, I don't think is so much of an issue.
But counsel, if I may, I hear you on the 2 points, but again, I'm looking now to form, he's not here to defend himself, so I'm having to do it by proxy. Given that the chairman made the first move to close the proceedings to the media, fine, then he comes now at the end of the proceedings and speaks to the media. And with your descriptor of irregular about that particular move, I'm saying to you that perhaps it is the chairman, in wanting to control the narrative around the details of the proceedings and not wanting the media to perhaps go down the road of fanning the flames around any flashpoint or any striking development from the proceedings. So he says, all right then, in not wanting to do that, to eliminate that, I'm closing it to the media, and then I will brief the media at the end of the proceedings because of the great public interest that cannot be killed off. It cannot be removed, no matter what happens. So I'm saying that he could level that as a defense of why it is that he's been speaking to the media at the 2 days when the proceedings ended.
And if that's the approach he wants to take, which may be a reasonable approach, that what you have to do is you have to rule, you have to make provisions in the way you conduct the proceedings. You say to the parties, I'm going to be making a neutral statement at the end of day one. Do the parties agree to this neutral statement? Yeah. And we agree, and then he makes a neutral statement. It's either in camera, quite frankly, or it's not in camera. Yeah. You can't try to control the narrative, particularly from the chair. Yes. The chair is there to see the evidence, see where the evidence falls, and make a fair and balanced decision, which is my primary concern. Because if we look at it from the flip side, often people think lawyers, or as we were termed, representatives, just want to win. Yes. Of course we want to win. And we think there's some very compelling mitigating circumstances, which, in my view, the panel have sought to close their eyes to, as I said, through this applying of these very draconian methods. But aside from the fact that they've tried to close their eyes to these methods, or to the evidence, the concern about procedural irregularities is not just if we lose. Of course, if Ms. Williams gets a very favourable result, which we still hope, and there's still the potential for her to get, the panel may, in the cold, after some mature reflection, realise they made some mistakes in the conduct, and they've got the evidence and review it and so on, and give the right and proper penalty, or outcome, I should say. That is then subject to WADA appeal, potentially, because it was such a procedural mess. But
on the point of appeal, and before Mariah comes with the question of the Court of Arbitration for Sport, which I know she'll ask, I want to ask you this. What about those counsel who say, and I'm putting it bluntly to you, that look, all this talk about procedural mess and the irregularity in the handling of the proceedings and the red flags that that Williams' team is raising, this is just setting the stage for when they lose the matter, to be able to say, oh, well, you see, we knew that this thing was compromised because procedurally it was all over the shop, and Mr. Gammon has betrayed his role as chairman, and he wasn't impartial, he wasn't fair. Some people are saying that you're laying the ground for that complaint when you lose. That's certainly true. I think the latter 2 points you made about Mr. Gammon, I think that's certainly fairly laid. But as I said, and I want to emphasize my previous point, my concern, or part of my concern, as a responsible representative for Ms. Williams, is I'm thinking, if we get a favorable outcome, because let me tell you, the mitigating evidence is compelling. If we get a favorable outcome, WADA may look at the process, right? The external bodies may look at the process and say, what's going on here? And frankly, as someone, I have Jamaican heritage, and as someone who pays keen interest in Jamaican sports, and particularly track and field events, right? I had expected a much more rigorous, a much more fair, and a much more balanced approach to these type of proceedings, specifically because it is so important to this country. It is so important. It needs to be done properly. And if it was done properly, and if it was done fairly, nobody could complain about the outcomes. And quite frankly, external parties looking in should be looking at Jamaica, as they do on the track, right? And they should be saying, well, yeah, that's a good proceeding. That's a good, fair process. And we can have some confidence that these athletes that are getting, minor penalties or no penalties at all, we can have confidence in the process that sits behind that. And I, quite frankly, couldn't go out there and say that I have any confidence in this process, and in particular in the way that it was conducted. I don't want to put too fine a point on it, but it really was a disappointment.
Dr. Crown, he constantly says, not giving a verdict will punish the athlete twice. Does that mean you all are going to withdraw her from?
Well, I'm glad you asked that, because that's a further procedural irregularity. And I hate to sound so much like a lawyer, but it's staring me in the face. If the panel do not render a decision, and this is part of the narrative that Mr. Gammon is trying to fight against with his latest statement, part of the issue is, or the primary issue is that if the panel does not render a decision by tomorrow,
right,
it would be, quite frankly, reckless for the athlete to compete. And so she has indicated that she is willing to reluctantly withdraw. And why? Because obviously, the obvious implications.
Because if she runs, they'll disqualify her.
Well, potentially.
Yeah,
that potential exists, and not just her. It potentially could have a knock-on effect.
The relay pool, the relay teams, the group effect.
Yeah.
Yes,
And just mentally going into a race not knowing where you
Yeah.
stand on something.
I mean, it's unacceptable. She's a minor. It's yeah, it really is.
Let's. So we hear that there may be an approach to CAS and what can CAS do? Can CAS order the panel to expedite their proceedings and give them a bracket to say, well, within this time frame, you ordinarily should be able to return a finding, a verdict?
Well, the Jamaican statute, as I understand it, as it was explained to me by counsel, the Jamaican statutes provide for a decision to be made within 20 days of the reference having been made to the independent panel.
Yes.
That, by our calculation, was yesterday, and possibly the day before.
Yes.
So really, a proper decision, the headline outcome ought to have been rendered by the panel on Tuesday.
Okay.
That not having been done, and even outside of that, there's the option to appeal to CAS on the basis that a failure to give a decision is effectively, it's a decision, right? You're saying, I'm not going to give a decision. And so you can appeal on that basis.
Okay.
All right. Well, it's I can't say disappointing yet, but what I'm saying is I can understand the frustration of the parties, and I can understand from the perspective of defending counsel the frustration with the process as you see it. I can understand Kent Gammon's his approach to sharing information with the media, especially as it was closed. And I can even understand some of the complaints about how the proceedings have been marshaled, given the experience of the persons on the panel. Persons who, two of the panelists I know particularly well, including the chairman, and I know what they've been exposed to in this regard. But we hope for the best. Counsel, thank you very much for coming, and we wish you all the best in your endeavors and your work.
Thank you for having me.
Good. So the panel will return its findings sometime in the Briana Williams case. And, well, I can tell you, as a commentator, we should leave it neutral, but I wish for the best for the young woman, I can tell you that. Let's take a break.